Welcome to The Explainer. Today we're moving way beyond textbook theory for a dynamic revision of your Year 3 modules. We're going to transform dense legal doctrines into the actual operational systems that govern our businesses, our homes, and our human legacies. This isn't just about memorizing rules, it's about seeing exactly how the theory you've absorbed applies as a living, breathing framework in the real world.
Here is our roadmap for today. We're looking at 4 interconnected legal pillars: ethics, the professional compass; business, structures and survival; property, registration and intensification; and finally, wills, administration and legacy. Let's dive right in.
Section 1. Ethics, the professional compass.
So, ethics. It basically solves a massive core conflict. How do we maintain public trust when a client's specific interests clash with justice itself? Take the Amiana case. Lord Justice Moses hit the nail on the head here. Ethical behavior within the legal profession isn't just about bare legality. It's not just about avoiding criminal acts. It's entirely about society's elevated expectations. When solicitors fall short, it's not just a personal slip-up. They actively damage the entire profession. It shows that society demands a higher foundational standard where the public absolutely must trust the practitioners who hold the power to uphold the law. To maintain that vital trust, solicitors are bound by the foundational Solicitors Regulation Authority principles. These serve as your strict, non-negotiable compass for literally every single action you'll take in practice. Notice how acting in the best interests of each client is just one piece of a much larger puzzle. It sits right alongside upholding the rule of law and maintaining public confidence. So imagine a client asks you to hide a key document in commercial litigation. Acting in their best interest to win the case immediately collides with your duty to the proper administration of justice. That exact tension is why these principles exist and why mastering them is absolutely crucial for your revision.
Section 2. Business law, structures, and survival.
All right, let's step into the engine room of the commercial world. Business law has to constantly balance entrepreneurial risk with creditor protection, and it all kicks off by asking yourself one crucial question. What exactly is separate legal personality? Understanding this concept is the master key. It dictates how businesses are structured, how they raise massive amounts of capital, and most importantly, how they successfully isolate risk.
And the answer to that question, well, it actually lies with a Victorian bootmaker. The Salomon case is the landmark precedent that established the corporate veil. By declaring that a company is its own distinct legal person, the courts allowed it to own property, enter into contracts, and be sued completely separately from its human directors or shareholders. Think about Mr. Salomon's bootmaking business. When it eventually failed, his personal assets were shielded from the company's creditors. It's a brilliant legal fiction that essentially birthed modern capitalism, because it encourages risk-taking by protecting entrepreneurs from total, devastating personal ruin.
Now, as a practitioner, your job is choosing the right vessel for your client. It's always a trade-off, right? A partnership might offer less formal structure and fluid governance, but it comes with terrifying shared, unlimited liability. A company, on the other hand, grants that vital protective shield of limited liability we just talked about. But in exchange for that incredible protection, the law demands strict corporate governance, directors' duties, and intense public reporting requirements. You are basically trading privacy and operational freedom for financial safety.
But what happens when the commercial engine stalls? Business law relies on specific insolvency routes to carefully balance the rescue of a failing company with the protection of the people it owes money to. The law intensely cares about saving a business if possible, because saving a business means saving jobs and stabilizing the economy. So whether it's administration to keep trading and restructure, liquidation to wind things up in an orderly fashion, or voluntary arrangements to renegotiate debt, the law provides a highly regulated off-ramp. It completely prevents a chaotic free-for-all and ensures commercial failure is managed fairly.
Section 3. Property, registration, and intensification. Property law addresses a massive foundational conflict. Who exactly owns what in our increasingly crowded world? For a system of property law to work, each item has to be allotted to an owner to provide stability. But the physical world is changing rapidly. We're seeing a massive acceleration of housing intensification. This cheek-by-jowl living radically challenges our historical concepts of exclusive property possession. Whether it's prompted by urban planning, global real estate flows, or organic responses to skyrocketing housing costs, the sheer density of modern urban spaces is actively transforming property law right before our eyes.
This increasing density, which is explored extensively in contemporary social welfare law, breeds complex new conflicts around shared resources, inequality, and the absolute limits of spatial rights. The old models of property ownership that heavily stress absolute exclusive possession simply don't cut it for regulating high-rise, multi-layered urban living. I mean, think about it. How does exclusive possession really work when you share a roof, essential structural cladding, and communal heating systems with 300 other people? That shared reality creates immense regulatory challenges that modern property lawyers have to navigate every single day.
To manage this complexity and potential chaos on a transactional level, property practice utilizes a strict, step-by-step operational system. Following this exact conveyancing sequence is what reduces uncertainty and makes abstract legal rights actually usable in the real world. It's all about registration and priority. Is an interest registered? Is it protected by a notice or a restriction? Skipping even one of these steps, like failing to identify a third-party interest, means the entire transaction can collapse, leaving your client exposed to massive financial loss. This process is how theoretical land law doctrine is forged into secure, transactional reality.
Section 4. Wills, Administration, and Legacy. Finally, we reach wills and probate, which resolves the absolute chaos of succession. When someone passes away, their property doesn't just sit in limbo. There's a highly structured legal process to manage it. Before any assets move, legal title has to be acquired via a grant of representation. But the vital difference here depends entirely on whether the deceased laid out their own blueprint or just left it up to the state. If they died intestate, meaning without a will, it acts as a cautionary tale. The state steps in with cold, statutory rules to appoint administrators, often leading to unintended beneficiaries. But if they left a valid will, the deceased hands the keys to hand-picked executors, trusted individuals legally empowered to administer the estate exactly according to their specific written wishes. Because a will powerfully dictates legacy, the law imposes incredibly strict formal and mental requirements. Under Section 9 of the Wills Act 1837, it must be in writing, signed, and properly attested. But beyond the physical document itself, the testator must possess testamentary capacity. They must truly understand what they are doing, the extent of their property, and the claims of those who might expect to benefit. Furthermore, it must be entirely free from undue influence. In today's world of aging populations, complex wealth, and blended families, undue influence is a heavily litigated area. Without these rigid, uncompromising safeguards, the entire system of transferring human legacy would just fall apart under the weight of fraud and coercion.
So, take a look at the physical and commercial world around you. As you wrap up your revision, take a moment to realize that these aren't just dry textbook rules. They are the very scaffolding of human society. From the ethical compass keeping professionals accountable, to the corporate veils enabling enterprise, the property registers sorting out our crowded cities, and the strict rules of probate securing our legacies. The real question is, now that you understand the machinery underneath it all, how are you going to use it to shape the legal landscape of tomorrow?